Most construction lawsuits take between 1 and 3 years to finally resolve. I'm Alex Bell, a construction lawyer in Texas. For over a decade, I've been helping construction companies and other parties to projects defend from claims, lawsuits, and arbitrations involving breaches of contract and alleged construction defects and other disputes. If you're having a problem with a construction dispute or you're involved in litigation or arbitration, give me a call to see if I can help you. My number is 972-328-9615, and you can call and schedule an appointment to see how we can work together today. Most contractors think of court as go to court and argue, but litigation is actually much more drawn out and protracted. Initially, the parties have to file a lawsuit, they have to file the petition, they have to get service of process. That takes time, and then the parties have to appear and answer. After they've appeared and answered, the court will sometimes put into place a scheduling order that determines when the case will get tried or when the other phases of the case will take place. And there's often a really long period of time called discovery, where the parties exchange documents and information about the claim and about the case. Oftentimes this includes depositions, this includes expert reports, and on big projects, it can include exchanging terabytes of information that lawyers and experts have to spend their time reviewing and combing for information that either rebuts or supports the claim. All of these things together can take between 1 and 3 or even more years to try and resolve. During the pleadings phase, the lawyers for the parties are putting their arguments together. They're roughly outlining the legal causes of action, the jurisdiction of the court, and other matters that are going to set the foundation for the case later. Oftentimes, they also have to describe in detail the damages that are sought, or at least the categories of damages that are being sought for the dispute. The pleadings are important because they phrase the case as either tort claims or contract claims, terms that have significance for lawyers and judges as your case is being decided. The pleadings phase is also when the defendants get to establish their legal defenses and deny specific issues that are alleged by the other side. So it's an important phase of the case that can stretch on where the lawyers are establishing the legal grounds on which the case is going to be prosecuted and defended. Discovery is the phase of the case where most of the time and money is spent. Construction cases often involve large volumes of documents and information that lawyers and experts have to review. This can include the need for a vendor or an outside company to provide or house all of the electronic information like emails and project documents in a form the lawyers can look through and search later. Lawyers are looking for documents and information that support or rebut the claims that are being made by the various parties. Looking through all of this information, determining what's helpful and what's not, and deciding what to use can take tens to hundreds or even thousands of hours depending on the complexity of the case. So that's where most of the time and money is spent in a case, is looking through documents and doing discovery to determine what the facts of the case actually are. A motion for summary judgment is a way to try to get a case dismissed before it goes to trial. A motion for summary judgment asks the court to dismiss the case because there's no dispute about certain facts that mean a case should be dismissed and that a plaintiff can't support certain claims. So for example, if a claim is brought too late past the statute of limitations or repose, a party can move for summary judgment and try to attach evidence that establishes that the claim was brought too late. If the court determines that there is no fact issue, that the case was too late, they can grant summary judgment and dismiss the case. Trial in a construction case looks like trials in other cases, but is usually more expert-oriented. Most jurors do not have a lot of experience with construction, or may have very limited experience with their own homes or apartments or businesses. And so it's important to have experts from the industry that can clearly and effectively explain things like construction standards, economic damages, and other complicated issues from construction cases in a way that jurors can understand. And so these witnesses are often critical to the outcome of cases. And so it's important that you hire a construction lawyer who's got a deep bench of experts they rely upon and who can hire the right expert to make sure that they can effectively make your case if it goes to trial. In the event of a bad result from trial, a party always has the option to appeal. Depending on the nature of the error that happened in the trial court, it could be likely to win an appeal or it could be nearly impossible to win. It just depends on whether anything went wrong at trial and whether that affected the outcome of the case. That is usually the lens through which the appellate courts look at the issues that are raised during trial to determine whether the judge or jury got the issues right. The biggest mistake contractors can make when they know litigation is coming is destroying evidence which can devastate their case, or not preserving evidence that could help them win the case. Going all the way back to the origins of the project or the dispute, keeping good daily records and documentation is the best thing you can do to protect yourself from future claims. Hopefully you never need it, but in the event of an adverse claim, having documentation from the time the issue happened during construction is the best thing you can have to help make sure you can defend the claim adequately at trial. If you're dealing with a payment dispute, need to file a lien or bond claim, or have questions about your insurance coverage on a particular construction project, give me a call today for a consultation. Dial 972-328-9615 and we can set up an appointment today.